Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. For today's case, we are dealing with a qualified immunity decision where it's police officer versus police officer. This is a case of Brandy Cunningham versus Thomas Castloo. In this case, a police officer found what they believe to be problems in a fellow officer's employment history. So there was a DD-214 that reflected prior military service. And this officer thought the DD-214 that they were reviewing was fraudulent or was otherwise being audited because they themselves had military experience. And so they thought that this one was fraudulent or had been changed or edited in some way. And so they reported this to their chain of command. And for their good work in being detective and realizing that this DD-214 was potentially fraudulent, they themselves were fired for bad conduct. So we're going to learn, does it pay to report your fellow police officer when they lie regarding their own military history? Let's get started with this. Brandy Cunningham worked at the Woods County Sheriff's Office as a deputy in April of 2016. Before that, she worked at the Hopkins County Jail. During Cunningham's shift at the jail, one of her supervisors asked her to review a DD-214 of a jailer named David McGee. Cunningham concluded, based on her military experience, that the DD-214 was altered. So one of her supervisors asked her to review this DD-14 of another jailer. And Cunningham concluded, based on her own military experience, this DD-214 had been altered or modified. Now, whether or not that's actually true, who knows? But that was the conclusion that she came to, that it was altered. On Wednesday the 18th, Cunningham approached Tony Cruz, a Wood County criminal investigator, and asked about how she could go about filing a federal crime because she realized the DD-214 might be altered, which might be a violation of federal law, one would imagine, right? She believed that she had an obligation to report that, in her opinion, McGee's DD-214 was altered. She came into some information. She thought there might be a problem. She'd like to report it to a competent law enforcement authority, such as the federal government, who would be in a position to determine if it's fraudulent based on access to the originals, right? Cruz told Cunningham to bring her concerns to Sheriff Castillo, so to bring it to the sheriff of the county. Okay, so on Thursday the 19th, Cunningham and Cruz met with Sheriff Castillo. Cunningham told Castillo that she suspected McGee had altered his DD-214. So I went to the sheriff and be like, hey, I think there might be a problem here. This DD-214 looks like it might be fraudulent. Maybe this guy has been lying about his resume and his background. Maybe that would be a problem. And this is where the sheriff said, wow, that sounds like a real bad problem. This guy is lying about his report. Maybe we should do something about it. Maybe we should look into it further. Maybe we should ask the federal government about it and whether or not it's authentic or not, because this guy might have been lying to us the whole time. Thank you, officer, for discovering this so that we can get to the bottom of this issue. That's what the sheriff said, right? Right? On Friday of the 20th, Cunningham met with Sheriff Castillo and Chief Deputy Bobby Sanders. Sheriff Castillo called Cunningham a liar, okay, and said that the only reason she was doing this to McGee was because how she hated him. She made it up. The DD-214, there's nothing wrong with it. The reason that she's reporting on this was because she hated him. Now, presumably, one way to determine this might be to get the original DD-214 and determine whether or not there's any veracity to that claim or not. But, why bother with that kind of detail? Sheriff Castillo asked her numerous times how many people she had told about her suspicion that McGee had altered his DD-214. She gave Sheriff Castillo the name of everyone she told within her chain of command. Because Sheriff Castillo was yelling at her, however, she said that she forgot that she had told Deputy Bowering. Neither Sheriff Castillo nor the deputy told Cunningham she's under investigation for lying and violating the chain of command. So this officer was asked to look into a jailer's DD-214 and determined it might be fraudulent. And she was told, she asked an investigator, who can I report this to? And he said, report to the sheriff. So she did that. And now the sheriff and the chief deputy are calling her a liar and saying you're making it up. You're lying about this person because you hate them. Now, we could determine whether or not maybe that's true, based at least in part on determining whether it's authentic or not by asking the federal government. But we're not going to do that. We're just going to accuse this person of lying for no particular reason. Okay, let's do that. On the morning of Monday the 23rd, Cunningham met with Chief Deputy Sanders, Lieutenant Burge, and Captain Holland. Thereon, she told she was being fired for improper use of the chain of command and lying. You went outside your chain of command. What is this, a few good men? We believe in words like code, honor, loyalty. We use them as something we believe them. You use them as the beginning of a punchline. We're full Jack Nicholson here in A Few Good Men at this point. She was not told how she lied or how her use of chain of command was improper. It was improper because you ratted out a fellow law enforcement officer. She asked to speak with the sheriff at the time, but she was told that she's not allowed to speak to him because we're going to fire you for the lying. We're not going to ask the federal government if it's a lie. We're just going to accuse you of lying. Super. The next day, the sheriff signed Cunningham's F-5. The F-5 is filed with the Texas Commission of Law Enforcement and indicates the nature of an officer's discharge: honorable, dishonorable, or general. Sheriff Castillo designated the discharge as dishonorable, which is the only option when an employee is found guilty of either lying or lack of clarity. Since Cunningham was dishonorably discharged, she has not found further work. So some places do hold officers accountable for their bad deeds, so they can't be merely rehired by another law enforcement agency. That's good. But when that process is being used as retaliation for a person making a claim that you don't like, that's bad. So they were given a dishonorable discharge, and now they can't find work because they had the temerity to report, I see a problem. I see a problem. The problem is you're reporting on this. Wait, what? I thought that's what I was supposed to do. No, you had a mistake. With thin blue line, man. Thin blue line. Sheriff Castillo contends the district court erred in denying him qualified immunity on summary judgment. Let's begin with the doctrine of qualified immunity. So the sheriff would like to say, I did nothing wrong, and even if I did, I have qualified immunity. So I did nothing wrong for firing this employee for making stuff, even though they probably weren't. And if I did, it's qualified immunity. So let's find out if the sheriff has qualified immunity. What is the standard for qualified immunity? A lot of you people probably know this already. Qualified immunity shields the government from civil liability in individual capacities, so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. The clearly established prong is difficult to satisfy. Yeah, that's definitely one way of putting it, that it's difficult to satisfy. We've covered enough qualified immunity cases on this channel to have a pretty good idea of just how difficult to satisfy it really is. It is pretty difficult to satisfy, yes. A right is clearly established only if it's sufficiently clear that every reasonable official would have understood what they're doing is violating the right. No, you can't be expected to understand everything. Ignorance of the law is totally cool when you're the police for some reason. Don't ask questions. That's qualified immunity. What do you want from me? I'm just here to report on it. A case directly on point is not required, but existing precedent must have placed the statutory or constitutional question beyond all of debate. When an official raises qualified immunity on summary judgment, the person that's suing has to prove that the other person is plainly incompetent and they knew better and it's clearly established. So they're the one who has to prove the government not only did a bad, but knew that they were doing a bad or should have known they were doing a bad because it was clearly established. So it's up to this officer who was fired to prove their other officer knew better, should have known better, didn't know better, and all those things. Do we think that they're going to be able to do it? Will they be able to prove it's clearly established? Well, let's find out. What is the standard for firing a governmental employee? The 14th Amendment is the source of substantive law that dictates whether the sheriff is entitled to qualified immunity. In a prior case, we relied on the Supreme Court cases interpreting the 14th Amendment to recognize a government employee's procedural due process right to name clearing her in certain circumstances. So maybe an employee has a right to have their name cleared. We declared it beyond any doubt that discharge from public employment under circumstances that puts a public employee's reputation or honor or integrity at stake gives us rise to a liberty interest under the 14th Amendment to a procedural opportunity to clear one's name beyond any doubt. If this is going to impugn your reputation, you have a right to clear your name. So surely it's clearly established, right? We have said that a government employee deprives an employee of liberty under the 14th Amendment if the government employee discharges the individual under circumstances that will do special harm to the individual's reputation and fails to give that individual an opportunity to clear their name. Well, that certainly sounds really, really promising. Under the prior case law, we've held that there is a property interest in being a governmental employee. And you have a right, if you're being fired, especially if it is going to put your public reputation or honor and integrity at stake, to a right to have a hearing to clear your name. And this has been clearly established and beyond any doubt. And if you are being deprived because you are being discharged, and this causes you special harm because it will harm your reputation, you have an obligation and you have a right to have a hearing that will clear your name. And that didn't happen. And so this employee will clearly win this beyond any doubt, clearly established right, codified by our prior decisions, right? Right? Let's read on and find out. Thus, against this background of qualified immunity and the substantive law of the 14th Amendment, we move further to address the merits of the case. The district court concluded on the facts as viewed most favorably to Cunningham. The sheriff violated Cunningham's clearly established procedural due process right by denying her request for a name-clearing hearing. The district court said that Cunningham had this clearly established right to clear her name of these stigmatizing charges. Clearly establishing that right in the district court view were two prior cases. The district court read the prior case to clearly establish a government's right to notice an opportunity to be heard when the employee's good name, reputation, or integrity is at stake. The cited cases, however, SpaghettiOs. The cited cases, however, do not reflect clearly established law under the facts as presented in this case. This case has nothing to do with those other cases, saying you haven't noticed an opportunity to be heard when you're being discharged because of reputation. This is totally different than those other cases. Neither of the prior cases clearly prohibit the sheriff's conduct in the particular circumstances before him. So not so much clearly established, no. The district court's reliance on broad pronouncements from the prior case evinces a methodological error because they looked at it super broadly. It established a defined law, too general, for any controlling relevance in this particular case. Courts must frame the constitutional question with the specificity and granularity, and the district court did not do that. Instead, the district court appears to have asked whether, generally, the procedural due process right to a name-clearing hearing was clearly established. The wording is the wrong way to frame the question, as the Supreme Court has repeatedly told us. This is too general. The district court asked generally whether you have a right to a name-clearing hearing. They didn't ask about it under these specific circumstances, though. Nice. The dispositive question we emphasize is where the violative nature of the particular conduct is clearly established. The answer here is no. No, not clearly established. Don't know what you were thinking of, but no. Having first described Sheriff Castillo's particular conduct as reflected by the summary judgment record and viewed in Cunningham's favor, we now ask whether the violative nature vis-a-vis the Constitution was clearly established. We conclude it was not. Specifically, the law was not clearly established that Cunningham's request to speak with the sheriff constituted a request for a name-clearing hearing in the context of our stigma plus infringement test, such that denying the request would amount to a procedural due process violation. Our cases are quite clear, even confusing, on what constitutes a request for a name-clearing hearing, so that makes it not clearly established. What is clear, however, is that none of our cases, and certainly none from the Supreme Court, holds that an employee's request for a name-clearing hearing triggered procedural due process protections when she asked only to speak with her boss in the context of a discharge. So that isn't a name-clearing hearing. You didn't ask for a name-clearing hearing. What would be a name-clearing hearing? We have no idea. But this wasn't it. So what is it? I don't know. Ask us again, and we'll tell you that's not it either. Of importance, granting the request to speak with the sheriff would not have resulted in a public forum of any sort. It would have resulted only in a private audience, which is not a name-clearing hearing for some reason. We sum up. In this opinion, we have fully accepted Cunningham's version of the summary judgment record as true. We have held even under this view, the sheriff is entitled to qualified immunity. The law was not clearly established that the sheriff's particular conduct violated the procedural due process right to a name-clearing hearing. Because the alleged violative nature of the sheriff's conduct was not clearly established as unconstitutional, we reverse the district court's denial of qualified immunity and remand this court for further opinions not inconsistent with this opinion. Thus, that brings us to the end of the case of police officer versus police officer qualified immunity in Brandy Cunningham versus Thomas Castillo, which proves that the police don't always win a qualified immunity case, particularly when the police officer themselves is the plaintiff. So in this case, Miss Cunningham was fired for suggesting a DD-214 was improper and going outside her chain of command in violation of Colonel Jessup's condemnation from a few good men. Colonel Jessup told us to never go outside the chain of command, and she apparently didn't learn that lesson, and she went outside the chain of command, and she was fired with dishonorable discharge, so she can't get another job. And she wants to say, hey, I was denied the hearing on to which I was entitled. And the Court of Appeals for Fifth Circuit says, hey, you looked at this way too generally. The courts have held you have a right to a hearing, but they haven't determined you have a right to the hearing in this particular case. So you didn't say what the magic words were. What were the magic words? We have no idea, but you didn't say them. So, Don't rat out your fellow police officers, I guess. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.